My name is Tyler Droste. My firm is Gutwein Law. We're happy to be participating this year in Evansville Startup Weekend, and excited to get involved. We're really kind of hoping to expand our presence down here in Evansville. I've been down here somewhat working remote for the past year and a half, and we just hired a new attorney and going to be getting some physical office space downtown. So we're really hoping to grow our presence down here and serve all the entrepreneurs in the Evansville area. And so my presentation today is, Startup 101, getting started. And I'm first going to talk a little bit about our firm and kind of give a brief history about our firm, talk about the primary thing that everyone's going to be looking to do initially with entity formation when they're first starting a business, and then we'll answer any questions that anyone may have. So one of the things that Gutwein Law prides itself on is being a good fit for startup companies, not only because we have expertise in that field of law, but also a lot of our attorneys themselves have started their own business or have had family businesses or grew up in a family business. And we really feel like having that business experience and perspective really lends to our ability to provide good legal advice to our clients. And that's kind of where our motto, legal strategies with business perspective, really comes in. And so our firm is a full service business boutique firm. I usually tell people it's easier to say what we don't do. We don't do anything like family law, criminal law, medical malpractice, personal injury like that. We tend to cater to businesses and business needs. That can include business law, intellectual property law, which is where I focus the majority of my time, patents and trademarks, employment law, real estate transactions, commercial litigation, sports law, mergers and acquisitions, private equity, early startup financing. And we also do trust and estate work as well, because we service a lot of smaller to medium-sized businesses that may be family-owned. And so setting up trusts and estates within those confines can be incredibly important. So getting to kind of the meat of the presentation here, entity formation. This is typically when you're working with a startup, one of the first questions is going to be, have you formed an entity yet? And so questions to consider here: when you should form your legal entity, what type of legal entity fits your situation, what legal documentation is necessary, and what is preferable, which will depend upon which kind of entity you want to form. And then we'll answer some questions of, hey, what maybe you haven't been thinking about but are also pressing, as well as just getting your entity formed altogether. So going to the first one, when to form. As with most things, earlier is generally better, right? So sooner rather than later. If you are currently already operating, you're technically operating as probably a sole proprietorship if it's just you operating the business, or a general partnership. And so typically if you're operating under these laws, you're going to be falling under the general Indiana business law statutes. But what you're also potentially doing is exposing yourself to personal liability operating as a sole proprietorship or a general partnership. And what that is, hey, if you were to say you were providing products to someone and there was a products liability lawsuit, they would not only be able to potentially come after the company's assets, but maybe even your personal assets. So some common triggers for forming formal entities include getting an initial investment in from investors, or maybe even you personally putting money into the company, forming that partnership or bringing a second party in. So as I just mentioned, liability and potential liability exposure. So if you're going to be selling products, providing services that may create these potential liability issues, you really want to start considering forming an actual legal entity formed with the state, which I'll talk about a little bit here a little bit later. Credibility. So when you're going to be pitching at these pitch events, depending upon what stage you're kind of at and what level the pitch event is, one of the first things is going to be, how are you formed and have you already formed your entity? So it lends a little bit of credibility if you've already formed your entity. And then creation of intellectual property is a huge one as well. So typically, especially with patents, the owners of the patent are the inventors. And what you'll see is people will form an entity to put that patent ownership into the entity itself instead of each individual inventor owning the So those are some triggers to forming the entity. So what entity fits my situation? The most common entity types that you see and that people are probably most familiar with are corporations and LLCs. These are, quite frankly, the two that almost every entity, especially a startup, is going to be formed under. Some of these can be formed initially as an LLC and then merge into a corporation at a later date. You don't often see someone forming a corporation and then merging into an LLC later. It's just a little bit more complicated. Other options that may be available are LLP, so limited liability partnerships, limited partnerships. A big one that's been kind of hitting, I guess, the market just recently are benefit corporations. This is really similar to a regular corporation, but it requires an additional element of accountability to the board and what the company is actually doing. A lot of startups have kind of looked into moving in this direction, depending on what service they're providing. We deal with those a little bit, but we oftentimes try to maybe not push people away from them, but let them know that, hey, that it may create an inherent difficulty down the road to get an increased investment at some point. Nonprofit corporations and then series LLCs, which are also relatively new. But going back to the two primary ones, there's corporations and LLCs, and more often than not, you're going to be forming one of those two entities under one of those two entity structures. So why choose one versus the other? And so one of the biggest reasons is a tax perspective. So a pass-through taxation versus a double taxation. With a limited liability company, you're going to be taxed in a pass-through manner, meaning any income you get from the company is going to get passed to you as the owner, and you're going to get taxed at the regular individual tax rate. Whereas with a corporation, it has a double taxation scheme where the company will get taxed, and then any distributions that are made outside of the company will get taxed at a different rate. So this is a big consideration that most people take into account. I won't go too much into detail. There is what's called an S corp election that you can make if you do file as a corporation that can result into you having this pass-through taxation structure. But there are some limitations as to what will qualify you to make that election. Another one is, how formal do you want your entity to be? So this question is inherently important as to the structure of the corporation or the LLC itself. Is a corporation has a very rigid structure of having a board, having your president or vice president, your officers, and then you would have your shareholders. And this rigid structure requires more documentation, more potential meetings and approvals, and can just create, I don't want to say inherently more difficulties, but it could just create a more rigid structure that an early stage company may not want to venture into immediately, especially if you're not anticipating on taking on investors very soon, which kind of brings it to the next question. Whereas an LLC gives you complete flexibility on how you really want to set up the corporate structure and the organizational documents. So investment timeline, like I mentioned, really kicks into it too. We typically say, hey, if you're not planning on taking outside investors for a year to 1 to 2 years, you may be best forming initially as an LLC versus a corporation, just to give you a little bit more flexibility in your entity structure and not have as many rigid rules as a corporation would require. As I mentioned from the initial onset, is it's easier to merge from a LLC to a corporation down the road. And oftentimes, if you're going to be bringing on a large investor, they're probably going to want you to amend certain organizational documents anyways. And so it's a natural point of potentially changing from an LLC to a corporation when you are bringing in that large investment. And so it's not something that necessarily would preclude you from forming as an LLC, because everyone hears, hey, I need to form as a Delaware corporation. That's what investors, what venture capitalists want me to format. Well, That is true. Most of the time, they're going to want you to form as a corporation, and it's either going to be in Delaware or or in the state that VC fund is located in. But if you're bringing on a VC investor, it's usually going to be for a large sum of money, and they're going to want a lot of other things done as well with an organizational document. So it's a natural transition potentially from an LLC to a corporation, to where you could operate as an LLC initially, and then once that larger investment comes, merge into a corporation. This gives you a little flexibility because early stage investors may not care if you're formed as a LLC or as a corporation. And again, it goes back to tax perspective. A lot of times, institutional investors are not going to want to incur that pass-through taxation, where a angel investor may not care as much at that point of the investment. So as I mentioned, what do I prefer? It largely depends. I'm going to give you the typical lawyer answer here, right? It depends on what your answers are to those initial questions. What is your investment timeline like? If you're 1 to 2 years out from taking on institutional investors, then maybe it makes the most sense to just form as an LLC at this time. Forming, especially if you're operating in Indiana, forming it as Indiana LLC is extremely cheap compared to other states, and it's going to probably suit your purposes in the interim until you start actually growing your company and bringing on more institutional investors. Is there a particular choice that is common in the industry? As I mentioned, when you get into larger investors, they're going to want to see you formed as a corporation, potentially as a Delaware C Corp. And so that is a preferred entity structure type later on down the road. But in the initial formation stage and early on startup, I think it's safe to say that forming it as an LLC in the state that you are primarily operating out of is probably the most preferred. So going to that process, I kind of hit on it a little bit initially. The process of forming an entity here in Indiana is, quite frankly, fairly easy and fairly cost effective. And when I say forming an entity, it's primarily filing these articles of incorporation or articles of organization with the Secretary of State's office. The ISBDC presented earlier. I think this is an area that they can definitely help you with getting that initial filing done. It's about a $100 fee to form in the state of Indiana to file your articles of organization or articles of incorporation. The next step after that is where we typically would come in. So it's not uncommon for us to work with a client who's already formed their entity and got their articles of incorporation, but maybe don't have any organizational documents. And so the organizational documents themselves are what sets forth the company structure and how the company is going to be run. So your bylaws and your operating agreement. Bylaws are typically going to be referred to in a corporation, whereas your operating agreement is for a limited liability company. And these documents kind of basically lay out how the company is going to be ran. Is there going to be a manager? Is there going to be a board of managers? Is there going to be a single manager, or is every member going to be a manager? It's also going to include property assignments, so transfer of ownership of real property or intellectual property. It's going to include share certificates / membership units. This is a semantics thing. It's a share certificate if it's a corporation. It's a membership unit if you're operating as an LLC. So this is the evidence of your ownership. And then another thing we typically will include with our package is a ledger and a recap of ownership, breaking down how many shares have been issued to each one of the owners or members. And then you may also have other agreements like buy-sell agreements that will restrict the transferability of the actual shares or membership units of the company itself. Because typically when you're forming an initial entity, you're bringing on certain people or you're forming it with certain people for a particular reason, and you don't want someone to freely be able to just transfer it to whoever you want. And so this buy-sell agreement, along with provisions in the operating agreement or bylaws, may restrict the ability to transfer those shares. And then the next step is taking the necessary business to actually operate the business. So adopting these organizational documents by getting signatures from all the necessary parties and holding an annual meeting formalizing them and also approving any other changes in the entity, obtaining a tax ID number, which is critical. With the last step here, which is opening a bank account, it's extremely critical that you have a separate bank account for your entity for liability reasons. That's one of the big things, big no-nos of if you're just forming an entity for liability purposes, but you're operating a bank account out of your personal account. If it ever went to court, the court may say, well, you're operating basically just a shadow company to evade a liability and have a liability shield, and therefore you're not really operating the entity for its particular purpose. And then the other one is filing the necessary tax elections and or documents annually. So that election would be maybe an S Corp election that I mentioned earlier. So what agreements are necessary and what's preferable? Obviously, we kind of talked about some of these. So the ones that are absolutely necessary are the articles of incorporation and organizations, and those are the ones that get filed with the Secretary of State. I didn't mention this earlier, but the operating agreement bylaws, those don't get filed with the actual Secretary of State. The only thing that gets filed with the Secretary of State is your articles of incorporation and organization. And then your SS4 is extremely necessary if you want to have a separate EIN for creating a bank account. The documents that are very preferable, especially if you're not a single member LLC or a single shareholder corporation, are operating agreements and bylaws, because they would set forth that in tandem with your organizing consent resolutions would set forth the ownership breakdown of the company. So if you and one other person have started operating a company together, and say you have formed your LLC through articles of organization, but you haven't effectuated any kind of operating agreement to break down the shares of ownership, without something documenting that, it's going to be assumed that you're operating at a 50-50% ownership. And maybe that's not the actual intent. So these documents are increasingly important when there's more than one party that's an owner of the company. Vesting agreements are very critical at an early stage startup, especially clients that we work with that may be starting up out of a college or university where, hey, we have someone who is working on a project with us and they're really dedicated now, but hey, 9 months from now, maybe they're moving, maybe they're graduating. We gave them 30% of the company and now they're nowhere to be seen. Well, without a vesting agreement to maybe table and structure out how their shares are going to be allocated to them, we just gave up 30% of our company to someone that isn't going to be participating anymore. So vesting agreements can be very critical in an early stage startup, and then IP assignments as well. And then the nice to haves are the buy-sell stockholders agreements, restricting the transfer of the shares further, so the shares can't be freely transferable to whoever a holder of the shares may want to transfer it to. And that may result in the company having the ability to buy back the stock, or the other shareholders having a pro rata opportunity to buy these shares back. And so lastly, the did you consider kind of options. So placing restrictions on founders' equity. So founders leave, now what? This is kind of the situation I just laid out with a vesting agreement. If a founder leaves, they may have a large share of ownership in the company. What's going to happen? These buy-sell agreements in place or a vesting agreement can really help cover those cases. Putting in place IP assignments is incredibly critical if you're going to be developing IP, whether it's a patentable, copyrightable material, and ensuring that the company is going to own those works. And then another one that gets often overlooked is doing an initial trademark search. You'd be surprised at how many people come and say, hey, here's my company name, here's what we want to do, and here's what we're doing. And then you go do a quick trademark search and find out that, hey, someone's already doing this, operating under a fairly similar name. And so it's more of an impetus at the front end to consider that before you really get tied to a name and really start building your brand under a name that you may not be able to operate under. So I know that was a quick crash course on some entity formation and other items to kind of consider when forming your startup. So I'd be more than happy to take any questions at this time. Like I said, it was a very quick run through, a lot of information, so I don't anticipate anyone to be an expert, but it was more or less kind of outlining some of the things to really start considering and when you're initially forming your company.
Thanks so much, Tyler. Really appreciate that rundown. If anyone has questions for Tyler, they can drop them in the chat or in the Q&A section, and we'd be happy to moderate one or two of those. Tyler, in the meantime, what's the best way for people to get in touch with you? They want to follow up.
So yeah, you can definitely reach out to me via email. I can put that in the chat. It's just tyler.droste at Gutwein Law. You can visit our website at gutweinlaw.com. You can find me there. My contact information will be on there. I'm also more than happy to discuss anything on the phone. If anyone has any questions, more than happy to take a call and discuss. So I can put some of that information out here as well. Did that come through in the chat? I just put my...
It did. It is. I'm going to transfer it to the main stage chat. It's in the backstage chat, but I'm going to transfer it for you. Thanks so much for doing that. Grant's already ahead of me. Thanks, buddy. All right. And I'm getting word that there's a question in the chat. I'm just going to look quick and see if that's in the backstage or the event chat. And whoever asked that question, feel free to throw it in the chat once more.
It's over on the stage
Patents.
Chat.
Okay. Yep. Well, it's all right. So patents, question about patents. So imagine we're in Germany enjoying a beverage. Use your imagination which beverage it is. So much so that we want to train under brewmaster, learning his secrets. We come back to the States and learn the recipe is unique, but not patented. So we think this is good. No one should have it besides me. I'm going to patent it for exclusive brewing at my home brewery. Is that something that's feasible, something that's allowable?
Yeah, so there's a lot of issues already with this scenario. One, you're in a foreign country, potentially learning trade secret matter from a brewmaster. And so if I'm not entirely sure what Germany's trade secret laws are, but I'm assuming they're probably similar to ours, where we may be misappropriating trade secrets in Germany, bringing them back to the US. And typically with a trade secret, you're not going to want to really patent it, because as soon as you patent it, you are putting it out to the public to see. And so if it's a recipe, these are typically things that we like to keep as trade secrets. See the Coca-Cola recipe, Pepsi recipe, Kentucky Fried Chicken spices recipe. You aren't going to see patents for these because they can't be reverse engineered as easily. And the issue with the patent is it's a 20-year term limit. So you get a monopoly for 20 years, but after that 20 years runs out, then anyone else can copy it. And so this instance, I would recommend keeping it a trade secret, but you're potentially misappropriating a trade secret from another party. So you may be breaking the law, especially if you ever intend on selling the same beer overseas into Germany as well.
Okay, well, that leads us to a follow-up question. So let's say they come back from vacation, but then Eric Steele decides that he has independently dreamed up the same exact recipe. No collaboration, just accidentally, right? And he has the same thought with the intent to build a mega brewery. So he's not going to keep it to himself, but he wants to go out and use it. How does the USPTO give preference if both parties were to attempt to file? Is it first to file, first to invent, discover?
Right.
What's
the
precedent?
So the US patent system just recently, and by recently, I guess it's been surprisingly, I guess almost 7 years now, switched to a first to file system. Prior to that, it was a first to invent system where the first to actually invent it had preference, even if someone maybe filed for a patent before them. We rejoined the rest of the world to a first to file system, because that's how the rest of the world operates, as to it's a rush to the patent office to get your patent filed sooner rather than later. And the winner, the race there, is given the spoils. And so the sooner we can disclose it, the better. As he mentioned, independent development doesn't preclude someone, and that's the one downfall of a trade secret, right? If someone independently develops your same recipe, you can't really go after them for anything if they didn't misappropriate that secret. And so that's where there's a trade-off between keeping something a trade secret or maybe filing for patent protection on it. And usually that's influenced by how easily something can be reverse engineered.
Brewmasters of the world, take note.
Brewmasters
Recipes that you're holding. Maybe time to get in line and get to the patent office.
Thanks for being on with us, Tyler. It was
Tyler.
fantastic. And thank to you and your firm for being not only a sponsor, also a presenter and a prize giver. So thank you.
Yeah, no problem. Thank you guys for having us. We're, like I said, excited to be involved, and sorry for any commotion that may have been in the background.